All right, and welcome, folks. I actually wanted to kind of go back and start over reading from some of the main documents. And I think where we're at, I want to start with Vanzan. And that's just because I feel like here in the next few weeks, this may play a big part in some of the things that we are visiting in terms of what's happening on the docket with the other filings coming our way, because we are approaching the deadline for a lot of things to start taking action. There were asks for extensions, etc. And so starting Tuesday of this week, we might see a lot of movement on those past decisions that were kind of put in a pending status. And now, as of Tuesday, December 2nd, we are going to see a lot of movement happening in relation to those prior extensions. Also on Wednesday, there should be more decisions made based off of prior extensions, etc. So coming into the holiday season, we're going to be seeing a lot of action coming our way. So just kind of want to get grounded. And the document that I want to read from is the Vanzan documents. And this is the one that was filed September 27th of 2024. Hopefully I'm going to do a deep dive later into Vanzan, as I know a lot of people have. But there's still questions that I have that I don't think I've seen other people talk about. Let's get into Vanzan. And again, this was filed September 27th, 2024. That was a Friday. So September 27th, 2024, on a Friday, whoever from this lawyering office went in to file these documents. So here we go. This is from the Vanzan Inc., who are the plaintiffs, against Does 1 through 10, which is inclusive of the defendants. The basis for venue is CPLR 503A and C, because plaintiff's principal place of business is in New York County. Plaintiff's address is 888 7th Avenue, New York, New York, 10106. I want people to make note of that, because this is the first time that I'm even registering right now that this is the address that is put on the very first cover page for the Vanzan subpoena. That's going to play a big part later on in the deep dive behind Vanzan that I go into, hopefully in a later video. I'm not sure if it will be the next video, but I know that I've kind of been in a holding pattern since last Friday, and this was something that I for sure wanted to start tackling right away. So, to the above named defendants, you are hereby summoned to answer the complaint in this action and to serve a copy of your answer, or if the complaint is not served with this summons, to serve a notice of appearance on the plaintiff's attorney within 20 days after service of this summons, exclusive of the day of service, or within 30 days after the service is complete, if the summons is not personally delivered to you within the state of New York. And in case of your failure to appear or answer, judgment will be taken against you by default for relief demanded in the complaint. So I want to just take note of that, because this is kind of standard practice when there is legal filing out there. This is usually something that does happen when there is no response. This little statement here: judgment will be taken against you by default for relief demanded in the complaint. So essentially, if the opposing party fails to appear and there's no opposition given, it acts or serves as essentially the opposing side just not even opposing the request, not opposing the action. And so when a default judgment is made, it just goes in favor of the person filing the paperwork. So in regards to this subpoena, it's basically saying, oh, if you fail to appear and there's no opposition given, judgment will be taken against you by default for relief demanded in the complaint. So essentially, not appearing means this subpoena will be served as it is provided and asked for. The basis for venue designated in this action is CPLR 503A and C, because plaintiff's principal place of business is in New York County. Plaintiff's address is 888 7th Avenue, New York, 10106. Dated New York, New York, September 27th, 2024. Respectfully submitted, Manat Phelps and Phillips, LLP, by Samantha J. Kotz, 7 Times Square, New York, 10036, provides the phone numbers, the fax number, and the email for Samantha Kotz. Attorneys for Plaintiff Vanzan, Inc., to Does 1 through 10, inclusive. Okay, and now we're right back into the main portion of the Vanzan document. Again, Vanzan plaintiff, Does 1 through 10 are the defendants. Plaintiff Vanzan, Inc., by and through its attorneys, Manat, Phelps, and Phillips, LLP, for its complaint against the unnamed Does 1 through 10, inclusive, hereby alleges as follows, which, mind you, part of the reason why I'm reading this document in full is because it wasn't until I read it again a couple of weeks ago that I really clued into a few different things. I know we read them. I know that we went over it when we first got these documents and when we first became aware, but having all of the information that we have now, it was kind of like, wait, why didn't I cue into that detail the first time that we read this? Why am I only just now registering that these are the things that this document is saying? So there's some details here that are going to be pretty important when we do the deep dive. So remember, by and through its attorneys, Manat, Phelps, and Phillips, LLP. Until reading this document again, I, for whatever reason in my mind, had constructed the idea that this subpoena was filed by Blake. Not really sure if she had representation either with her or doing this on her behalf. But it was the last time that I read this a couple of weeks ago that I was like, oh no, Manat, Phelps, and Phillips was a part of creating this subpoena and was a part of filing this. It's not just that the subpoena exists. It's not just that this was filed potentially by Blake, allegedly. It was that Manat, Phelps, and Phillips was a part of the process of drafting it up and filing it. So, nature of the action. 1. The action arises out of an ongoing campaign to damage plaintiff's business and plaintiff's reputation. 2. Upon information and belief, the Doe defendants have certain contractual and confidentiality obligations and obligations of good faith and loyalty to plaintiff regarding plaintiff's business and reputation by way of oral promises and or written agreements, which somebody made pretty good call out. I mean, it's like one of those things that it's so obvious, but until somebody says it, it didn't even blip on my radar. Dogs apparently are bothered by me. So the comment from somebody recently, apparently it's like when mom goes on the phone, suddenly they have to have your attention. So the comment that somebody made recently that seems so obvious that it feels almost unnecessary to say until somebody says it, and then you're like, oh yeah, because this is filed under the idea that they don't know who the Doe defendants are, which is the reason why you file against Doe defendants, because you don't know who they are. You're unsure of who the defendants are that you're up against. But these statements, it's not really plausible to file a Doe defendant type of subpoena if you know that there are oral promises and written agreements. If there are written agreements, you know who the Doe defendants are. If you have oral promises, you know who the Doe defendants are. So 3, despite these obligations, the Doe defendants have undertaken direct efforts to contravene these agreements and instead have participated and may continue to participate in efforts to harm plaintiff, including by failing to act in plaintiff's best interests, taking actions to their personal benefit at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impact the plaintiff's business and reputation, and disclosing to third parties and failing to keep strictly confidential plaintiff's confidential and or private information. 4, this conduct constitutes breach of the agreements and obligations owed by the Doe defendants to plaintiff and has caused significant reputational and economic damages to plaintiff. 5, this complaint seeks to recover compensatory economic and non-economic damages, as well as other appropriate remedies against the Doe defendants. The parties. 6. Plaintiff is a New York corporation with its principal place of business located in New York, New York. 7. Upon information and belief, each of the Doe defendants are individuals and/or companies that are domiciled, reside, have their principal places of business, and/or are incorporated or organized in New York. At this time, plaintiff is not privy to the names or identities of the individual defendants, Does 1 through 10, and therefore sues these defendants by such fictitious names. Upon information and belief, the Doe defendants are employees, contractors, agents, or representatives of plaintiff who have participated in and possibly conspired with others in a scheme to damage plaintiff's business and reputation in breach of their oral and/or written promises to plaintiff and their duties of good faith and loyalty to plaintiff. Pursuant to New York Civil Practice Law and Rules, CPLR 1024, upon discovery of the actual name and identity of Does 1 through 10, plaintiff will substitute such information in the caption and in jurisdiction and venue. 8. This court has jurisdiction over the parties and subject matter pursuant to CPLR 301, 302A, 1, 302A2, 302A3, and/or 302A4. This court has personal jurisdiction over the Doe defendants who, upon information and belief, carried out activities against plaintiff in close connection with their contractual relationship with and related duties owed to plaintiff, and are domiciled, reside, have their principal place of business, and/or are incorporated or organized in New York. Alternatively, the court has personal jurisdiction over the Doe defendants who, upon information and belief, transact business within the state, contract to supply services in the state, have committed tortious acts within the state, have committed tortious acts without the state that have caused injury to plaintiff in the state and regularly do or solicit business, or engage in another persistent course of conduct, or derive substantial revenue from services rendered in the state, or expect or should reasonably expect their tortious acts to have consequences in the state and derive substantial revenue from interstate commerce, and/or own, use, or possess real property situated within the state. 10. Venue in New York County is proper pursuant to CPLR 503A and C because plaintiff's principal place of business is in New York County. Factual background. 11. Upon information and belief, the Doe defendants have certain confidentiality obligations to plaintiff regarding plaintiff's business and reputation arising from, among other things, oral or written agreements and/or duties of good faith and loyalty, collectively the Doe duties. So again, there's reference to oral and written agreements, which would suggest that you would at least have an idea of who these defendants possibly are. So 12, specifically, plaintiff provided consideration to the Doe defendants in exchange for the Doe defendants' agreement to act in plaintiff's best interests, not take actions to their personal benefit at plaintiff's expense, freely communicate with plaintiff regarding matters that impacted plaintiff's business and reputation, and keep strictly confidential and not disclose to third parties plaintiff's confidential and/or private information. 13. Upon information and belief, in or around August 2024, the Doe defendants breached the Doe duties by acting in a manner that was inconsistent with and damaging to plaintiff's best business interests and reputation. 14. Upon information and belief, the Doe defendants' conduct included but was not limited to failing to act in plaintiff's best interests, taking actions to their personal benefit at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impacted plaintiff's business and reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and/or private information. 15. Upon information and belief, in or around August 2024, the Doe defendants disclosed plaintiff's confidential and private information to third parties. 16. Upon information and belief in or around August 2024, the Doe defendants became aware of and failed to inform plaintiff about conduct by third parties that had a reasonable likelihood of causing, was designed to cause, and did cause irreparable harm to plaintiff's business interests, and plaintiff's reputation. 17. Upon information and belief with regard to the foregoing, the Doe defendants have acted with negligence and/or reckless disregard of the impact that their acts and omissions have had and continue to cause monetary damages and irreparable harm to plaintiff's business interests, and plaintiff's reputation. 18. Plaintiff has suffered significant monetary damages and irreparable harm as a direct result of the Doe defendants' conduct. First cause of action: breach of contract against Does 1 through 10. 19. Plaintiff repeats and realleges each and every part of paragraphs 1 through 18 above as if they were fully set forth herein. 20. Upon information and belief, plaintiff and the Doe defendants are parties to oral and/or written agreements which impose certain confidentiality obligations regarding plaintiff's business and reputation and require the Doe defendants to act in plaintiff's best interests, not take actions in bad faith or to their personal benefits at plaintiff's expense, freely communicate with plaintiff regarding matters that impact plaintiff's business and/or reputation, and keep strictly confidential and not disclose to third parties plaintiff's confidential and/or private information. 21. Plaintiff provided consideration to the Doe defendants in exchange for the Doe defendants' agreement to act in plaintiff's best interest, not take actions in bad faith or to their personal benefit at plaintiff's expense, freely communicate with plaintiff regarding matters that impacted plaintiff's business and/or reputation, and keep strictly confidential and not disclose to third parties plaintiff's confidential and/or private information. 22. Plaintiff has either performed or was prevented or excused from performing by the actions of the Doe defendants or the Doe defendants' agents and/or representatives all of plaintiff's contractual obligations. 23. Upon information and belief, in or around August 2024, the Doe defendants breached the Doe duties by acting in a manner that was inconsistent with and damaging to plaintiff's business interests and reputation, including but not limited to by failing to act in plaintiff's best interests, taking actions in bad faith or to their personal benefit at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impacted plaintiff's business and/or reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and/or private information. 24. In addition, upon information and belief in or around August 2024, the Doe defendants became aware of and failed to inform plaintiff about conduct by third parties that had a reasonable likelihood of causing, was designed to cause, and did cause monetary damages and irreparable harm to plaintiff's business interests, and to plaintiff's business and reputation. 25. Accordingly, the Doe defendants breached their duties and obligations to plaintiff set forth in their respective written and/or oral agreements with plaintiff. 26. Upon information and belief with regard to the foregoing, the Doe defendants have acted with negligence and/or reckless disregard of the impact that their acts and omissions have had and continue to cause irreparable harm and monetary damages to plaintiff's business and interests, and to plaintiff's business and reputation. 27. Plaintiff has suffered and will continue to suffer significant and irreparable harm for its business and goodwill, as well as monetary damages, as a result of the Doe defendants' breaches in an amount to be determined at trial. So with that said, I think this is kind of setting me up perfectly for where I want to go next. And it's why I've really enjoyed going back to the source documents and looking at things in retrospect, essentially working backwards through the timeline. I know we've gone through everything. We've been there basically from the start, and we have been combing through all of the details as they come forward. But it's kind of a good point to start working backwards, because I know we had kind of a lull the last couple of months before we've had this big onslaught of movement on the docket. And it was just like, a really good reset to kind of take a big breath and go back to see like what makes sense and what starts to fall apart, knowing what we know now in regards to looking at what was filed. Because at the time, it's brought up a lot of questions. It's made us wonder about certain things, like how did this happen? How did that happen? How do these pieces fit together? And knowing all the information that we do to this point, it's just really helped to kind of recalibrate and understand, some of these stories have absolutely fallen apart. And some of these stories have not only not fallen apart, but they have stayed steady since the beginning. And now going back to those documents, it almost solidifies where we're at now. Basically, reading this, what I feel like I want to read next is Jennifer Abel's request for the conditional motion summary judgment, because I think it's a really stark contrast to what is filed in this subpoena. Second cause of action, breach of covenant of good faith and fair dealing against Does 1 through 10. 28. And we're getting pretty close to the end. We're at page 8 of 11, so we're more than halfway. Plaintiff repeats and realleges each and every part of paragraphs 1 through 27 above as if they were fully set forth herein. 29. Upon information and belief, plaintiff and the Doe defendants are parties to oral and or written agreements which impose certain confidentiality obligations regarding plaintiff's business and reputation and require the Doe defendants to act in plaintiff's best interests, not take actions in bad faith or to their personal benefit at plaintiff's expense. Freely communicate with plaintiff regarding matters that impact plaintiff's business and reputation, and keep strictly confidential and not disclose to third parties plaintiff's confidential and or private information. 30. Plaintiff provided consideration to the Doe defendants in exchange for the Doe defendants' agreement to act in plaintiff's best interests, not take actions to their personal benefit at plaintiff's expense, freely communicate with plaintiff regarding matters that impacted plaintiff's business and reputation, and keep strictly confidential and not disclose to third parties plaintiff's confidential and or private information. 31. Despite these obligations, plaintiff is informed and believes that the Doe defendants deprived plaintiff of the benefits of their agreement and thus breached their duty to deal fairly and in good faith by, among other things, acting in a manner that was inconsistent with and damaging to plaintiff's interests and reputation by, among other things, disclosing confidential and private information about plaintiff to third parties and failing to inform plaintiff of information and conduct that had a reasonable likelihood of causing irreparable harm to plaintiff and to plaintiff's goodwill and reputation. 32. Plaintiff has suffered and will continue to suffer significant and irreparable harm to its business and goodwill as well as monetary damages as a result of the Doe defendants' breaches in an amount to be determined at trial. Third cause of action. And we are now on page 9 of 11. Faithless servant liability against Does 1 through 10. 33. Plaintiff repeats and realleges each and every part of paragraphs 1 through 32 above as if they were fully set forth herein. 34. Upon information and belief, plaintiff and the Doe defendants are parties to oral and or written agreements which impose certain confidentiality obligations regarding plaintiff's business and reputation and require the Doe defendants to act in plaintiff's best interests, not take actions in bad faith or to their personal benefit to the detriment of the plaintiff. 35. Notwithstanding these contractual obligations, the Doe defendants engaged in misconduct and unfaithfulness by disclosing unfaithfulness by disclosing confidential and private information about plaintiff to third parties and failing to inform plaintiff of information and conduct that had a reasonable likelihood of causing irreparable harm to plaintiff and to plaintiff's goodwill and reputation. 36. The Doe defendants' conduct substantially violated their contracts of service with plaintiff, and such violations permeated the Doe defendants' service in their most material and substantial part, and were directly against plaintiff's interests. 37. Further, as plaintiff's employees, contractors, agents, or representatives, the Doe defendants owed plaintiff a duty of loyalty, which required them to exercise the utmost good faith and loyalty in the performance of their duties, prohibited them from acting in any manner inconsistent with the trust placed in them by plaintiff, and required them to keep confidential plaintiff's private and/or confidential information. I hope you're listening to this and hearing the things that I'm keying into, because these are all of the points that we will visit when we read Jennifer Abel's conditional motion for summary judgment. I don't know if everyone here has been through these other dockets that I'm referencing or referring to, but it was so significant to read her motion for summary judgment and then to come back to Vanzan, because so much of what is said in the Vanzan subpoena could be true of what Jennifer Abel could say in regards, or Wayfair could say in regards to Jones Works and what happened in August of 2024. So it is very telling to me when I'm reading this document how these two situations they're going to be so closely tied together at some point. 38. At the time the Doe defendants owed such duties to plaintiff, they solely, for their own benefit, acted in a manner that was inconsistent with and damaging to plaintiff's interests and plaintiff's reputation by, among other things, disclosing confidential and private information about plaintiff to third parties and failing to inform plaintiff of information and conduct that had a reasonable likelihood of causing irreparable harm to plaintiff and to plaintiff's goodwill and reputation. So remember, this is all going to be relevant when we read Jennifer Abel's motion for summary judgment. 39. The Doe defendants' foregoing actions, individually and collectively, and we're on page 10 of 11, were adverse to plaintiff and constituted a breach of the duties of good faith and loyalty owed to plaintiff. 40. Plaintiff has suffered and will continue to suffer damages as a result of the Doe defendants' material violation of their contracts with plaintiff and their breaches of their duties of good faith and loyalty in an amount to be determined at trial. 41. As a result of their misconduct, unfaithfulness, contractual breaches, and violation of their duties of good faith and loyalty to plaintiff, the Doe defendants, at a minimum, forfeited the right to receive and are obligated to return to plaintiff any and all income they received from plaintiff from and after the commencement of the Doe defendants' wrongdoing, including, without limitation, all fees, bonuses, and profits received in connection with their work for plaintiff in an amount to be determined at trial. 42. In addition to compensatory damages and/or disgorgement, plaintiff is entitled to an award of punitive damages against the Doe defendants in an amount to be determined at trial, because the conduct underlying their breaches evinces a high degree of moral turpitude and demonstrates such wanton dishonesty as to imply a criminal indifference to their civil obligations. Prayer for relief. Wherefore, plaintiff prays for judgment in its favor and against the Doe defendants as follows. 1. For compensatory damages in an amount to be determined at trial. 2. For an order requiring the Doe defendants to return to plaintiff all monies of any kind they receive from plaintiff they received, past tense, from plaintiff, from and after the commencement of the Doe defendants' wrongdoing in connection with the work they performed for plaintiff. 3. For exemplary or punitive damages in an amount to be determined at trial. 4. Pre- and post-judgment interest as permitted by law. 5. For its costs of suit, disbursements, and reasonable attorney's fees. And 6. For such other relief as the court deems just and proper. Respectfully submitted, Manat, Phelps, and Phillips, LLP, by Samantha Kotz, 7 Times Square, New York, New York, 10036. Their telephone numbers and her email. Attorneys for Plaintiff, Vanzan, Inc. Dated New York, New York, September 27th, 2024. So it's a very short document considering all that it is, but it establishes, the venue It establishes jurisdiction. It establishes that there were contracts and agreements and therefore duties of the Doe defendants in relation to the plaintiff. And essentially, this document identifies that plaintiff, Vanzan, is the employer over or contractor over the Doe defendants, and that there was some form of payment from plaintiff to Doe defendant. I'm not going to argue that at this moment. I just want you to make a mental note that that's what this document says, that the plaintiff is the one who was in charge of and also made payments in regards to a contract with the Doe defendants. So it's not saying that the plaintiff is an employee of. I think that's where I want you to make the note, is that it's not arguing that the plaintiff was under the management or instruction or in service to defendants. Rather, it's saying that they were in charge over and had made payments to them instead of receiving payments. That is the Vanzan documents in full. And like I said, it wasn't until reading them again that I really keyed in on the address, as well as the fact that Manat, Phelps, and Phillips was a part of drafting up these documents and submitting them. For some reason in my mind, I thought it was just something that possibly Blake drafted on her own and submitted possibly on her own. So those are just some details that I want you to keep in your memory bank as we go through and read the motion for summary judgment from Jennifer Abel. I think that will be my next post. I just want to leave this kind of as a standalone post. That way we can use it as a reference and you can come back, you can visit this information. I know that there's some people who they want to hear this in the background. So I know the documents are out there, but I also did want to provide those few little thoughts as we go through it and try to keep the conversation about it down to a minimum. That way people can come back and use it as a reference. And that way you can listen to this while you do the dishes or, keep your hands busy with something else. So thank you for being here. I'm going to make, I don't know how many more posts tonight, but I know that there's a lot of other topics that I wanted to pursue and hopefully kind of tied together in a later post. So again, thank you.